IL&FS, the big one, which has defaulted on 5 repayment schedules since August, has sought protection for itself and 40 group companies from the insolvency process. Menaka Doshi now joins me with more details on this one. Menaka, you've been talking to lawyers as well. We've heard the IL&FS group approach the NCLT to take some cover in terms of protection. Where does this go legally from here, and what are the options?
Okay, so let me just add a little bit more detail to the news that you've just announced. What IL&FS has just informed us via stock exchange filing is that they filed an application with the NCLT under Section 230 of the Companies Act, which is the section that looks at schemes of arrangement and compromise for itself and 40 other companies, right? Now, if you just sort of dialed back a little bit and said, what were the options confronting IL&FS for a resolution route, okay? There is absolutely no specific legal framework for a company like IL&FS. And the reason why I say that is IL&FS is a core investment company which is systemically important and non-deposit taking. So in RBI parlance, it's known as a CIC-SIND. Okay? Now,
very simple.
Very simple, yes. There is no specific legal framework for a financial services firm of the nature of IL&FS. There would have been if the FRDI bill had actually been passed, because that bill actually envisaged a resolution corporation for financial firms of this nature, banks, financial firms of this nature, etc. But that bill got jammed for other reasons. So in the current legal framework, there were only 2 options. You go to the IBC or you go under the Companies Act. Under the IBC, financial services firms, there are no provisions for insolvency regulations or resolution for financial services firms. In fact, the IBC rules out financial services firms. There was one provision which said that the central government could notify a particular class of firms if it wanted to. So there was that option that if the central government wanted to say that, look, we want to make an exception for IL&FS, we're making a notification, it will get resolved under IBC. But that is not the case. The other option was to go through the scheme route under the Companies Act, which is what IL&FS seems to have picked. All very lovely for us, because just this morning we were discussing the pros and cons of using either one of these routes. IBC, like I said, they would have needed a special government notification. What the schemes route provides them with, the pros are this: a little bit more flexibility, whereby they can, within a scheme, look at raising of capital of funds, monetizing of assets, including writing down of debt. So what schemes allow, what this scheme could allow them to do is a debt restructuring of sorts.
This is under the Companies Act.
Under the Companies Act, it's Section 230 to 232, which looks at schemes of compromise and arrangement. So that's the route they've picked, because like I said, under the IBC route, they would have not technically qualified. They would have needed the government to make a special exception for them, issue a notification saying IL&FS can be done under IBC, and there is no existing framework. Also think of it this way: this is a group insolvency. This is not just the insolvency of IL&FS, because at the end of the day, IL&FS is the holding company.
Correct.
The stress is coming from underlying subsidiaries and underlying projects, and there are over 130 of them in terms of direct, indirect subsidiaries, some joint ventures, etc. So think of it as a group insolvency. They seem to have taken the Companies Act route for, like I said, the pros being that there will be flexibility, there will be ability to incorporate various different parts of a solution under a scheme.
Sure.
As they've mentioned, they're doing the scheme for themselves and 40 other group companies, so they would have identified the companies where the stress is maximum, and they would have then included them within the scheme, from what I understand. And they will now need creditor approval and or shareholder approval, and the final NCLT approval for such a scheme to go through. So we have to yet see the contours of the scheme. They have not made those available as yet. I'm sure that will take some time. But a scheme under Companies Act would need to go through approval of members, which is shareholders, creditors. If it involves debt restructuring, then you need 75% of the secured creditors to approve this. And you will obviously at the end of it all need NCLT approval. They've picked this route. There are a couple of drawbacks to this route, as experts have told us. One is that there is no explicit provision under schemes for a moratorium or a standstill. So what an insolvency proceeding allows you to do is bring a standstill to everything, right? Till you're able to figure out which parts need to get cured in what way. A scheme does not have an explicit provision for a standstill, but it does not bar a standstill either. So they can bake a standstill into the scheme and hope that the NCLT will approve that, right? That's one. Secondly, schemes could take, there is no fixed timeline for a scheme approval, as opposed to IBC, which has fixed timelines. But let's admit, IBC has also seen all those fixed timelines getting violated at various points.
Right.
Schemes could take 6, 8, 9, 10 months to approve, depending on the complexity of the scheme. So there is that bit of a drawback, one might say. The third thing that is possibly a drawback under a scheme is that a scheme is not omnibus to the extent that it doesn't override all other laws. The IBC was drafted and crafted to override all other laws. So income tax law, etc., was all overridden when a resolution plan was accepted under the IBC. A scheme does not override all of this explicitly. So it'll be still interesting to see what the interplay of other laws is when it comes to what provisions they're attempting to undertake under the scheme. But these are some of the drawbacks versus the big plus, which is the flexibility of being able to introduce various different kinds of solutions. Also, let's remember, if you went under the IBC route, technically that's an acceptance that you're an insolvent company.
Correct.
Which means that the shareholders are worth nothing, right? So I'm not sure in this situation LIC wants to be worth nothing or Oryx wants to be worth nothing, especially if they want to bring in, especially if they're going to bring in new funds.
Capital,
yeah. So in an insolvent scheme, equity shares mean nothing. You're only doing credit insolvency, right? Under a scheme of arrangement under the Companies Act, the shareholders will still retain their rights to a large extent. So I think these are some of the pros and cons of a scheme, which is why they seem to have gone down the scheme route. We need to, of course, look at the scheme in more detail once they publish that, and that will be a fairly long, big task for them to be able to come up with a scheme that covers all of this. But this is the beginning of the resolution process for IL&FS. Today was the first step that was taken, and it seems that they've picked the Company Act route.